Uh, Hi, everyone. Very good afternoon to all of you. I thank all of you for joining this webinar today on patent infringement and risk assessment. As you know that IP filing is increasing not only in India but all across the globe. And when IP filing increases, that also means that there is a lot of restriction on what kind of IPs you can use in your product or not. Sometimes without knowledge, also you might be using the IP which belongs to others. This today's webinar is more specific for patent infringement, but when a product is manufactured or designed, it's not just patent infringement, but it may be infringement of other forms of IP also. In fact, trademark infringement may also come into picture if your trademark is very similar to some well-known brand, and copyright infringement may also be there if there is a chance of or likelihood of piracy, or if there is any leakage of copyright through your ex-employee or any common connection between your company and the other party. Okay, so today's presentation primarily is focused on patent infringement, and I again welcome all of you, and we'll take up some questions at the end, and please feel free to post your questions in chat box, and we will take all of them at the end. Before I start, just confirm it to me whether the screen is visible and you can hear me. My audio is good.
It sounds good. I could hear it.
Thank you. Thank you so much.
It's good.
Thank you. So we are starting one course on FTU search. We'll talk about it later on. But this course is specially meant for the startups, business owners, and patent agents, practicing lawyers. So can you recognize these two well-known faces? Any of you? You can unmute and speak because I can't see chat box while I'm presenting. Who are these two faces? Let me give you a hint. They are brothers.
Add to Waxman.
Yeah.
They right
They are
this.
They are right brothers. Okay. So when you talk about patent infringement, we cannot, ignore one of the major patent infringement case studies in the history ever, that is Wright brothers. We all know Wright brothers to come up with the flying airplane, and before Wright brothers, nobody could even imagine that there could be a device which could, fly in the air. So they were inventors of a flyable airplane, and these two, they got into a serious patent litigation which affected their company also later on. So what I mean to convey with this case study is that the consequences of patent infringement may be really very serious for the companies, not only on financial front, but also they can take it can be a great it can have a great impact on their market reputation as well. So, coming to Wright brothers, their breakthrough discovery was the simultaneous use of roll control, and in March 1903, they applied for a patent on their method of control. The application which they wrote themselves was rejected. So, this is one important learning, that patent is a techno-legal document. So, drafting your patent yourself, maybe it may give a good feeling, but when examiner examines it, there are a lot of compliances which are required to be fulfilled. There is a format given in the Patent Act. So if you're not very sure about how the specification should be drafted, you should always hire an expert. Okay, so Wright brothers, they wrote application themselves and it got rejected later on. In early 1904, they hired finally a patent attorney, and that's how the patent was granted to them. And title of the patent was Flying Machine, and this was U.S. patent number 821393. And this is how the drawing of this patent specification looked like. So here you can see patented May 20, 22nd, 1906, title of the invention flying machine. And here is the name of inventor, and application was filed. The print is not very clear, and application number is here, and down you have signature of applicant or the patent agent. And after filing their patent application, because this product was good, it was innovative, and there was no other player, it was kind of new invention, if you really ask me. So Glenn Curtis, he was an American aviation and motorcycling pioneer and a founder of US aircraft industry. He infringed some claims of the patent of Wright brothers. And when the discussion happened, what happens, like typically when infringement of patent happens, both parties, they try to come together to work on the licensing part of it. But here Glenn Curtis approached Glenn Curtis refused to pay any license fees to Wright brothers and sold an airplane to Aeronautic Society of New York in 1909. So this was not a good step. So when you're using technology of third party and there is a possibility of settling it down by paying royalty fees, you must always do that. But Curtis refused to pay license fees. And then Wright brothers, obviously, they filed a lawsuit for patent infringement, and they won the patent infringement lawsuit against Glenn Curtis and other early aviators who devised fins to emulate lateral control described in the patent and demonstrated by Wrights in their 1908 public flights. In 1917, the Wright Company and Curtis Company had effectively blocked the building of new airplanes, which were desperately needed as the United States was entering World War One. Now, you can type in the chat box if you want to that how come the new technologies or new innovations blocked because of Wright Company and Curtis Company. If you have any clue, you can type it. Okay, just because these two companies, they were fighting for patents and they were very strong patents around the technology, then building of new airplanes was kind of blocked. So lesson to be learned is when you have a new technology, innovative technology, and especially when there is a war like situation where this technology is required, you must be open to grant licenses. And in order to overcome such situations, then we have compulsory license today in most of the patent laws across the globe, at least the countries who are compliant to TRIPS agreement. And maybe in 1917 there was no law saying that if there is a world war, the government can use patented invention for its own use. But now in India also we have a law saying that in case of national emergency, extreme emergency, government can make use of your patents even without your consent. The US government pressured the industry to form a cross licensing organization, the Manufacturers Aircraft Association, so that the technology is available to the manufacturers, especially in the situations like World War. All aircraft manufacturers members were required to pay a fees for the use of aviation patents for each airplane which was manufactured. And major part of this royalty which was collected from the manufacturers, it went to Wright brothers and Curtis companies until their respective patent they expired. After few years, one of the Wright brothers, he died, and the other brother, he sold his company and retired from his business altogether. The patent war, this is how patent war came to an end. The lawsuit damaged the public image of Wright brothers, who previously had been generally regarded as heroes. Critics said the brothers' actions may have retarded the development of aviation. So this is the worst thing which can happen to a scientist, that you create something, you patent something, but you are not open to licensing because of you, because you innovated. Growth of aviation industry got retarded. So this should not happen. When there is a new innovation, it should contribute to development of science and technology. The Manufacturers Aircraft Association was an early example of government enforced patent pool. Curtis and Wright brothers, their companies, they merged, both the companies, they merged in 1929 to form Curtis Wright Corporation, which exists to this case. You may read about this case study more in detail. It's very interesting, one of the most interesting case studies in the history so far. So now coming to what is patent infringement. You will be surprised to know that the word infringement has not been defined in patent law. How we derive meaning of the word infringement is from the rights of patent owner. Rights of patent owner are the negative rights, they are not positive rights. So when you have a patent, it does not say that you can now use it, it says that you can prevent others from using it. Okay, so that's why we say that patent rights are negative rights. Patent holder can prevent others from making, using, selling, offering for sale, and importing the patented invention in the country where there is patent protection. If there is a US patent, then you can prevent others from making, using, selling, etc. in the territory of US. But if you do not have a Chinese patent, then you cannot prevent anyone from making, using the patented invention in the territory of China. So patent rights are absolutely territorial. Let's look at this picture. Now, if any one component is patented by you, for example, this wheel kind of thing is patented by you, does it mean that you can manufacture the product itself? No, because you have patent only on this part. Rest of the components of this product may be patented by others. There may be possibility that design of the wheel is protected by somebody else, or the seat is protected by somebody else. So when you are patenting, when you're filing for a patent, you are getting protection only for a small part of it. It is very rare that the entire product is protected in the form of a patent. But when it comes to manufacturing, the equation and dynamics change. When you are manufacturing the product, you have to make sure that none of the components of the product which you are going to manufacture encroaches upon IP rights of third parties. I hope this part is clear, because this is the most important part of this presentation. Once you have understood this PPT in specific, rest of the things are easy for you. So if I have to now manufacture the entire product, I have to do due diligence for each and every part of this product to make sure that I am not infringing upon any third party's IP rights. Patent is a techno-legal document, and once patent claims is a portion of a patent which gives legal protection, and it defines scope of the patent. And when patent infringement happens, it is not infringement of the entire document, it is infringement of the claims, and claims are subject to interpretation. See, patent as such may be a document which is 30-page long or 35 pages long. Okay, average it is like between 20 to 30 pages long. And if you have described the entire invention in the patent document, there is only small portion of patent where you write the claims. You say that I have described everything, but I claim only one component of this invention. So you get rights only on the component or components which are described in the claims, and you have to clearly tell or explain in the patent specification that even though I have described everything, but I claim rights only over this particular component. And claims are written in a very tricky language. Mostly it is a legal language, and they are also subject to interpretation. How to read claim and how to make out meaning of that claim is something which is done in the courts when infringement of patent happens. And interpretation also, in your day-to-day life also, you see sometimes interpretation is very tricky. Your spouse says that spouse says anything to you and you interpret it differently, and he says that I never meant that, but then you say that I know always you speak like this. So like your normal conversation with your shopkeeper, with your children, with your husband or wife in the house, similarly patent claims are also subject to interpretation. And there may be a lot of tricky things when it comes to patent claims, because one term may be understood by a person in US differently, but the meaning of that term may be very different in China. Just to give you one example, morality, ethics, they have different meanings across different countries. But the golden rule to interpret claims is that you must understand plain and ordinary meaning, and you should not play around with the words and come up with the different interpretation of the words. When infringement happens, it is a patent holder who has to prove in the court that his product is infringed. Okay, infringer will not prove that he has infringed the product. So burden of proof to prove the infringement is always on the patent holder, because patent holder is the one who is going to initiate a lawsuit. But in very few cases where a patent is about a process, and process is very difficult to find out, like if I have made tea for you, it is very difficult for you to make out how I have made that tea, how much boiling, what is the ratio of different components. So similarly, when process patents are infringed and litigations happen, then the patent holder or judges, they find it very difficult to find out what process has been used to make the product. And in very rare cases, court may ask the defendant or the infringer itself to prove that the process he is using is not the infringing process. But otherwise, ordinarily, burden of proof is always on the patent holder. There is one search which is called as FTO search or freedom to operate search, which can be done before a new product is launched. So this is a kind of precautionary measure which companies can take before launching new products in the market. And the purpose of FTO search is to assess likelihood of patent infringement upon launch of new product in a specific market. The best time to perform this FTO search is at the time of designing new product, because if at the time of designing new product you find that there is another component patented by another company, then you can make changes in the product specifications. But if you have finalized your product and after that you are doing patent infringement risk analysis studies, then it may be difficult for you to make changes in product specifications. So best time to perform a freedom to operate search or patent infringement risk assessment is right in the beginning when you are designing the product. Step one to perform a patent search is that you must segregate the components. If you're doing FTO for the cell phone is a very big device. Actually, we can consider very simple device for FTO purpose. But let me take this example. If this is the product for which you are going to do FTO, then you have to open up everything and segregate into different components: the chip inside, the material of this glass, UI, dimensions of the product, then how does locking happens, what kind of software you are going to include in it, payment gateways. So find out all the components which are there in this device, and also those will be your keywords. Okay, so and keyword should be designed in such a way that you should use the terminologies or nomenclature which is commonly used in the industry. If water is the word you want to use as a keyword, then use the word water or H2O, because these two are the terms which are commonly used in the industry. But if you use the word hydra, aqua, then you may not get the relevant results, or you may get the results which are not even related to the product. So you have to be very careful about designing of the keywords. After that, after nomenclature of the product has been done, then you must find out synonyms of each keyword and formulate a string of keywords for doing the patent search. After patent search is performed, you will pull some you will pull some documents, and patent search should be done for each component. If there are 5 major components, then keyword search has to be done for all 5 components. And you must for FTO search, you should not pull patents of 50 years, 60 years, because those patents will always be expired. So to be on safer side, you can take 22 years, because term of patent is 20 years, but 2 years buffer maybe you can take. And when you do a search of past 22 years, you will pull the patents which are valid. Okay, and also now screening should happen. If you have to launch your product only in the US, then it makes sense for you to segregate the patents which are granted in the territory of US, because the patents which are granted in Japan are anyways not relevant for you. okay, because you are not going to do business there. So depending upon the countries where the business is going to be, you can select the you can perform your FTO search accordingly. And there is this World Intellectual Property Organization, WIPO. This is an international platform to file patent application. WIPO does not grant patents, but it is a platform to file international application. So there is a database maintained by WIPO which is called as Patent Scope. So you must perform patent search in Patent Scope also, because you may get list of patents which are going to be filed in US or India, whichever country you are interested in. Coming to step 4, now assuming that you have now shortlisted some 50 patents which are related to your product, then you can bucket them. You can find out which are in force, which have expired, lapsed, abandoned, and you must also differentiate very clearly between the granted patents and patent applications, because if patent is not granted, then you may probably have to track it to check whether it gets granted or not. For FTO search, most important patents for you are patents which are in force, because these patents are very risky for you. Expired patents are safe to be used. So I'm giving you a very generic statement that they are very safe to use, but you must always do due diligence and find out whether they are really safe to use or not. Then there are lapse patent. Lapse patents are the ones where the patent holder has missed paying the renewal fee, and patent office has changed the status to lapse. But lapse patents are very risky patents, because you should never consider lapse patent as expired patents, because lapse patent, they have one chance to get active again, so they can be restored by the patent holder by paying the fees. And abandoned term is used with respect to patent applications. And this is how you can segregate all the documents which you have pulled into various categories. Out of all, in-force patents are the most relevant for you. Then step 5 is that once you have shortlisted the patents which may be risky for you, you must go through the claims of patents. Sometimes people come and say that, I want to use this product, but this has been patented by a company X. But then I always tell them, have you read through the claims or not? You assume that the product is patented, but when you look at the claims, they have not even patented the product. So it's very important to understand claims of the patent and find out what is the overlap between claims of these patents and your product. If there is an overlap, then it may be a risky patent. You should not use it. But if there is no overlap, then there may be opportunity for you to use such patents. Shortlisted patents shall be compared with the product components, and claim charts shall be prepared, because claim mapping has to be done with the product. Based on the results of uh, first 5 steps, claim charts are produced, and then opinion on patent infringement shall be written based on the laws of the country where the product is going to be launched. It's very important that infringement opinion is written as per local laws of the country. If there is a FT report done for the US, then probably you should cite some US case laws, and if it is for India, you must cite some case laws in FT report which are India specific, because there may be some variation across the laws, even though all major countries today are complying to TRIPS agreement. If there are high risk patents, but you really desperately want to use it, and it happens, I tell you, it happens very often that companies, they desperately want to use the patents, but if they use it, it is infringement. But if they don't use it, then they lag behind their competition. And let's see how to handle these high risk patents. First of all, check expiry patent of the day of the patent. And sometimes expiry is just down the line, 2 months later patent is going to expire. So in that case, you can actually get yourself prepared to use the patent and wait for probably 2 months or 6 months, and that could be a good way to use the patent. And if the patent is going to expire soon, it is worth to wait for the patent to expire before using it. Much before this, you should check legal status of the patent. Okay, so to confirm whether it is really in force or not. Second way could be read through patent claims clearly and try to understand what is claimed. often the language used in the claims is very complex and expert advice must be sought. But read through the claims to find out what exactly they have claimed and what exactly you want to use. But if it is entirely different, then there may be a possibility for you to use that patent. Perform an invalidation search to understand how strong the patent is. Sometimes patents look very great, but when you perform invalidation search, and this invalidation search is done where we pull the prior art to find out what is the difference between the given patent and the prior art, and if there is enough prior art to invalidate the patent, then that patent may be considered to be weak patent. Generally, patent search is performed to reveal closest prior art and novelty or inventive step is assessed. If the patent is strong, you must think twice before using it. If the patent is weak, maybe you can apply for opposition. I'm just giving you very generic advice. So it's just one of the options, but don't take this as a legal advice. Based on the outcome of invalidation search, opposition to the grant of patent, if the patent is not granted, or post grant opposition or revocation may be filed. So this could be one of the ways you can use the patent. In case there is no other way out, then you may try to talk to the patent holder and see if he is willing to give you license. This may not be feasible in most of the cases, but because why would patent holder want to create a competition for him? And but still, you can always try it out if you want to. And one of the trick or hack you can say, which I use for FTO search reports, is I always see the track record of the patent holder. There are some companies filing great patents. They have great patents, good portfolios, but they have never filed a litigation. For you, it is very important that if in FTO search you read through the history of the patent holder and see whether it is a litigant company or not non-litigant company. What we what we discussed is like, there are few ways to handle the situation where there is high risk of patent infringement. If none of the steps work, then it is advisable not to use, I'll just highlight this, not to use the patent, because if patentee takes a legal action against you, it may be detrimental for your reputation and your business. Okay, so if there is no other way out, then don't use that patent. There was this interesting case between SmithKline Beecham and Fujimoto Pharma. SmithKline Beecham had filed a process patent in Japan on cimetidine, September 1973. It was granted after 8 years, long time, and valid till 1993. In December 1986, Fujimoto imported the infringing products from Yugoslavia and sold 68,000 tablets in Japan. Now, Fujimoto shouldn't have done it because they cannot import a product in a country where there is a patent protection. Fujimoto also manufactured a generic version of cimetidine, and SmithKline Beecham claimed that Fujimoto had infringed their patent from December 86 to September 93, that is almost 7 years. Fujimoto argued that their process was not covered by SmithKline Beecham patent. So this is normal argument which happens in the court, that infringer will never agree that he has infringed the patent. So judge found Fujimoto liable for patent infringement, and now you can see the kind of damages court provided. So yen 500 million and 2.5 million in lost profit based on 15% profit rate, and this was one of the largest award ever given to a Japanese company. So consequences of patent infringement can be really detrimental for the companies. Another case is from a pharmaceutical industry, because a lot of infringement happen in pharmaceutical domain. Celgene Corporation for cancer drug. So Celgene Corporation, they had a drug, cancer drug, Revlimidine, and upon ANDA filing by Sun Pharma, ANDA filing is done when another company wants to use the drug, and permission is required from the authorities, regulatory authorities. Celgene filed a lawsuit for patent infringement against Sun Pharma, but Celgene was kind enough to agree to grant a license to Sun Pharma for a specific amount of money to be paid by Sun Pharma as royalty to manufacture and sell the drug subject to US FDA approval. By providing a license, Celgene would allow Sun Pharma to manufacture and sell unlimited quantity of the drug in the US from January 31st, 2026. Before this case between Celgene and Sun Pharma, other companies also, other mostly Indian companies, Cipla, Natco, Cadila, Dr. Reddy's Lab, and these companies also, they settled patent litigations with Celgene. And Celgene granted a patent license to all these companies required to manufacture and sell the unlimited quantity of the drug uh, after January 31st, 2026. So I'll just conclude this presentation. Patent infringement is encroaching rights of patent holder, and it is an offense as per Indian patent law. And in fact, all across the globe, there is like same similarity in the laws. So it may be very risky to use IP of others, and it may get you into serious litigation. So clearance search, so FTO search, clearance search, patent infringement risk analysis, they are more or less they are similar. So clearance search may be an effective way to assess infringement risk and play safe in future. So it is really worth spending money on patent infringement risk assessment so that you can, with a lot of mental peace, you can launch your product in the market. And this is about the course. And in this 5 days course, 5 Saturdays actually, okay, every Saturday we'll have a class of around 1.5 hours. So we will explain how FTO reports are written, how search is performed, and how to interpret the claims. This is going to be very useful for patent agents and for the companies. And if you register for it through this, so participants of this webinar, they get discount. So you can make note of this early bird discount code. I will post in the chat box also, and you can join WhatsApp community also, which Origiin has, and you can make use of this program. And it's going to be a very good skill enhancement course for the IP practitioners more specifically. So thank you very much for joining this webinar today. And I will close my presentation, and we can see if there are any questions, we can discuss them. So I'll stop sharing the screen. So I have put information about the course registration link and all in the chat box. So if you have any questions, any additions, anything you want to share, please don't hesitate. You can unmute and speak. In the meantime, let me see if there are any posts in the chat box. Okay, Murli Krishnan says, any specific guidelines to prepare a case for approaching FTO analysis? Yes, there are some guidelines, and different professionals may use different guidelines, but there are set procedures to do FTO search. Harsha is saying, what are practical industry steps we take for infringement analysis? Practical steps are that you must get this search done before the new product is launched. A thorough opinion is really required. Rahul says, up to what period patent can be restored? Is it country specific? Yeah, it is country specific, Rahul. And once your date to pay renewal fee has gone, you are given 18 months where you can restore a lapsed patent. Pavitra says, is it not enough if I prove that the product that comes out of the said product is similar to that product that comes out of the patented process to prove infringement? For process patent, I mean. Okay, so for if it is a process patent, even though product has been manufactured, but process is very difficult to find out how the what kind of process has been used, what was the temperature, cooling time. So that's why burden of proof shifts on the infringer, specifically in the case of process patents. Sudhir says, do you need to obtain an FTO in India if the product is not patented in India? Yes. Uh, and FTO is not really dependent upon whether the product is patented in India or not. Okay, I think I understood your question wrongly. Do you need to obtain FTO in India? Okay, you will get to know whether product is patented or not patented after doing a patent search. Okay, and for one particular product, there may be numerous patents, but you may be aware of only one or two patents. So FTO search report reveals all the patents which are available or granted. Okay, another question is, please validate the following points. We should always monitor patent applications, not just granted patents, as the application may be granted in near future. Therefore, even after the product launch, we should continue monitoring for at least next 18 months since some patent. Yeah, I completely agree with you. So when FTO search is delivered, there may be some follow-up searches after 6 months or 1 year. The reason being that, as you rightly said, that there may be some documents which are applications today, but they may be converted to patents tomorrow, and they may turn out to be very risky for your business. That's absolutely right. Uh, Dr. Prashant says, who issues the FTO document? Dr. Prashant, any lawyer, law firm, like we also do FTO search reports. So it should be validated by a lawyer, and it should be signed by a lawyer, basically. I hope you found this webinar useful. Okay, Anshu Sharma is asking, ma'am, do we get placement opportunities after completing FTO course? Yeah, FTO is one of the searches, and most of the law firms, they need people to do FTO search, and we don't have much skilled people as of today, but we definitely need more specific people. Okay, Shiva Subramaniam, initially you have mentioned about how we interpret about the claims. In the similar way, during FTO, we found that we are not infringing. Later, when it was challenged, then the penalty for the client who did FTO and not done FTO are the same. Yes, sometimes it may happen that you may miss a prior art altogether, and interpretation of claims may be in the wrong way. And if you want to read through it, there is a Kodak versus Polaroid case study wherein Kodak received around 250 opinions from a lawyer, and if, in spite of that, they got into patent infringement. So FTO search is a good practice, but again, if something has to go wrong, it will go wrong in spite of FTO also. But the difference is that when lawsuits are filed and FTO is already done, the courts look at the infringer differently. So that may be possible, but yeah, after FTO also companies may get into infringement suit. Dr. Prashant says, does FTO search needed for separate countries where we want to go to after WIPO route and then file in? Yes, FTO search is usually country specific, but if you have some 10 or 15 countries, then you can get a global FTO search done. That is a single report. Barun Kumar says, many thanks. Thank you, Barun. Ashish Kumar says, how to handle patent families and continuation divisional applications where single invention may have related patents with different claims and different expiry date. So Ashish, all of them, they have to be taken into consideration. So even if it is patent of addition or divisional application. So everything which is enforceable, which is active, is a risk document for you. Vijendra says, if we already have a patent, can we make the product later, sometime of our invention? FTO search is still required, Vijendra, because you may have a patented component of a product, or there may be similar patents already available. Okay, so it is advisable to get FTO search done. So Murli Krishnan says, from a pharma context, is it necessary that FTO need to be conducted for every new product or any precondition can be assessed at our end. So preferably for every product you need FTO search. Shiva Subramaniam says that why patent search is not authorized by patent office. So I don't have answer of this question. So patent office cannot actually do it because this is something which is to be done by the court, and there is no authority which can guarantee that FTO search is done. So now you are free to do whatever you want to do. Something may come up, but yeah, if FTO search is done, and that's why the companies, they take opinion from 2 or 3 people. Most of the companies in the US, if you see, they take opinion on FTO from 3 4 companies to make sure that they are not missing out anything. Okay. Mathan Raj is asking, what if our product or process falls only independent claim of valid patent? Will it be still considered as infringement? This may be, this actually comes out because dependent claim also is dependent upon an independent claim. So definition of dependent claim is derived from the independent claim. So that's why claim mapping has to be done for independent as well as the dependent claim. Dependent claim does not have its own existence, so it has to be related to the independent claim. Vijendra says court means normal courts or IP have separate codes. So Vijendra, right now we don't have separate IP codes. So for patent infringement lawsuit, it has to be a court which is not inferior to a district court. Shiva Subramaniam, how often we need to do FTU? FTU should be done before a product launch, and it should be repeated after 6 months. Yeah, Harsha, it should be repeated because there may be some applications which are not yet granted. Today, if I do a patent search, okay, there may be some applications for which patent is not granted, but there may be change in history of those patents in next 5 or 6 months. So we must track it once to see if there is anything new which has come up. Ashish says, are patent agents allowed to search FTU? They can do. Patent agents can do. Shiva Subramania, why FTO is financially and time taken also higher than prior art search? Because FTO takes a longer time. Longer time, and analysis of claims takes a lot of expertise. That's why FTO search is mostly 3 or 4 times more expensive than the regular prior art search. Thank you, Harsha and Vijendra. Thank you very much. And I must say that it was a great audience, very mature and very nice questions came up, and I really appreciate your time. Somnath says, if a company's patent has a component that is only infringing point in another company's invention, then second company has got all options other than licensing. If a company's patent has a component that is the only infringing point in another company, then second company has what option? So licensing is one of the most, if you want to amicably settle the matter, then licensing is a good option. Okay, Neil says, do you do FTO on design patents also? Yes, of course. FTO is done not only for patents, but it is also done for the designs, and it is also done for designs, and holistically also for a product FTO can be done. Ashish says, in space and defense field, many inventions under secrecy law. Then how to handle FTO in these fields? Actually, even if there is secrecy direction applied on a patent, for time being, it may be there, but it definitely gets published at later point of time. Okay, that's even more a reason for FTO search to be repeated after 6 months. So when secrecy direction is implemented on defense related or space related inventions, it is only for a particular period of time, but later on they get published. And if they don't get published, then they don't come in the public domain anyways. Babita says, thank you for very good information shared clearly. Thank you, Babita. I'm glad that you liked it. We do check along with FTO with trademark infringement also, of course. Yeah, trademark infringement should be done. In fact, if you see how many infringements happen, then there is no comparison between the infringement which happen in case of trademark versus all other forms of IP. So trademark infringement and litigations are very, very high. So trademark infringement should also be checked. Is there a FTO for trademark? Yeah, there is FTO for trademark. So how trademark FTO is done? When you coin a new word, okay, suppose I want to start a company and I want to name my product, then right in the beginning, before finalizing my name itself, I should perform a trademark search and check if my trademark is similar to any existing mark or not, and what is the probability of getting objections for this particular trademark. If you take care of trademark search right in the beginning, you can do actually business very peacefully. I've seen companies getting into trademark litigations in very early times of their business, and that is not good. Atul says, if there is a research paper but not patent, can I use that process? Yes, technically speaking, yes, you can use, because there is no legal protection over a research paper. If there is no patent, that means that information is available. And for patent agents, FTO search is a good search to learn. You become little specialized rather than doing regular prior art searches. It is a more specialized search. Uh, in your FTO sessions, will you be also talking about trademark FTO? We have not thought of it, but if more participants are there for trademark FTO search, we can quickly cover it. Should not be a problem. Which website we do for FTO search? So if you want to do FTO search for Indian patent, then every country has actually patent database, so you can do country specific search there. Otherwise, if you want to go for paid tools, then you get comprehensive information about all patents in single platform. Can we do FTO search via AI? I'm sure you can do it, but you should be able to verify the results. Harsha says, if there are three components in a patent, and when after doing FTO search, I found references having similar or at least one component, then it will be considered for infringement. Plus, the claim has comprising transition phase. Okay, yeah.
No, forget about comprising transition phase. It depends upon.
Yeah, sorry. Can you be little loud? Can you be louder? Okay, Somnath says, according to your experience, which paid search engine has the best track record for FT searches? We are using PATS here, so we use that, so it is good. Okay, Neil says, thank you for this presentation, very helpful. Thank you so much. I'm glad you liked it, because your feedback and your comments really are very important for me. I read all of them, and they help me to get better and find out which topic is of interest to us. We will give you the recording of the session.
அது பால் குடிக்க மாட்டேங்குது என்கிட்ட.
Yeah, Pavitra, can you mute yourself?
Sorry, ma'am. It was my mistake.
No problem. Yeah. Okay, Harsha, your question, prior art search and FTO search, they are not same. Search process of digging out patents may be similar, but the outcome is entirely different. Okay, so if there are no more questions, we can close the session. I'll wait for another 1 or 2 minutes. Okay, I'm posting the link to register for the course again.